good morning, good afternoon, or good evening, depending on wherever you are. On behalf of the Department of Law, North South University, it is my pleasure and privilege to welcome you to this webinar on compensation in international law and the International Law Commission. Our guest this evening is Professor Martins Paparinskis. But before I invite our guest to deliver his talk, please let me invite our esteemed department chair, Barrister Arafat Hosen Khan. Arafat, over to you.
Thank you, Professor Rizwanul sir. Today's distinguished guest speaker, Professor Martins, my colleagues, dear participants, and our beloved student, good evening from Bangladesh, and a warm welcome to NSU Law webinar. Tonight makes a significant moment as we gather virtually for a discourse that promise to deepen our understanding of compensation under international law and the role of the International Law Commission. It is with our great pleasure that I introduce our distinguished guest speaker for this evening, Professor Martin, as a luminary in the field of public international law and a member of the prestigious International Law Commission. Professor Martin brings a wealth of expertise and experience that is sure to enlighten us on the nuance and complexities of compensation within the international legal framework. Our academic community at the North-South University takes pride in fostering a culture of intellectual curiosity and rigorous exploration of legal principles. Tonight's webinar is a testament to our commitment to providing a platform for engaging discussion and exchange of ideas that contribute to the broader understanding of international law. I encourage each of you to actively participate in this webinar, take the opportunity to pose any questions you may have and explore into the complicated world of legal particulars. Let us collectively embark on a journey of knowledge and insight as we listen to Professor Martins unravel the expertise surrounding compensation under international law. Once again, a heartfelt welcome to you all, and I extend my gratitude to Professor Martins for gracing us with his presence and expertise. Let the NSU Law webinar begin, and may it be an enlightening experience for all of us. Thank you so much.
Thank you, Arafat. I now once again invite our guest speaker, Professor Paparinskis, to deliver his speech. Over to you, Martins.
Well, thank you. Thank you much, Professor Rizwanul Islam. Thank you, Chair of the Department. It is a great delight to be here virtually at North-South University and to join the line of speakers that have contributed in this setting. I want to speak to you about, as was noted on the topic that relates to the work of the International Law Commission, of which I'm privileged to be a member, but it relates to its work, as it were, before my time. So my perspective will be mostly that of an academic observer, and as we discussed in the online part, this is something on which I have written academically before I was elected to the International Law Commission. So my interest is, I suppose, both a somewhat critical external one, as well as now having perhaps a somewhat better sense of the internal dynamics and the place and fit of the International Law Commission in the international legal order, as the chair of the Department of Law noted. What I want to talk to you today is a particular topic that has struck me for the last few years as a very important one. and that is a topic of compensation. Let me just say that, in my view, this is something that has become particularly important in the last 5 years, and overall fairly important in the last 10 years. So there is a trajectory, one might say, of importance. As a general sense, if we look at what international law says on the matter, within the 20th century, one might well conclude that its contributions are fairly limited. It is only in one case of the International Court of Justice in the 20th century that compensation was awarded. That was the very first contentious case that the International Court considered, the Corfu Channel case, where Albania was found responsible and was required to pay compensation. But ultimately, even in that particular setting, the court did not say much in general terms about how it arrived from the general proposition of compensation to a particular sum, because Albania had chosen not to appear before the court, and therefore United Kingdom submitted its own expert report, and the only thing that the court said was an evaluation in a rather curt manner on whether the expert opinion was reasonable. So we know something about the particular procedure, but we don't know really a great deal about the general rules of state responsibility. And that, in my submission, is what we are really interested in. The real characteristic of the law of state responsibility is that it operates in a manner, one might say, agnostic to the institutional structure. It may be implemented through international courts, arbitral tribunals, international institutions, or it is very likely, and indeed in most cases where disputes arise, it will be implemented outside any institutional structure at all. I want to note simply that the practice of international law has changed greatly in that setting since those early years. In the last few years, a great deal of practice before the International Court has squarely dealt with compensation issues. Last year, in February 2022, on 9th of February, the International Court handed down its judgment on reparation in the armed activities on the territory of the Congo case. This year, the International Court handed down on 30th of March its judgment in certain Iranian assets case between Iran and the United States, where the court found the United States to be responsible for a breach of applicable treaty rules and noted that compensation was to be calculated at a later instance. 3 cases were introduced earlier this year before the International Court, all three of them raising explicitly claims for compensation. And compensation is not something that is only dealt in a judicial setting. Within the institutional body of the United Nations, states have addressed the possibility of creating a reparations damages register in relation to invasion of Ukraine, and in particular regional settings, it has been taken further in the Council of Europe. And these are also matters that are routinely addressed in institutional bodies that deal with claims brought by actors other than states. And so in particular, human rights actors in regional human rights regimes and investors before investor-state arbitration tribunals. So these things are very important. Having introduced, and I hope persuaded you of the great importance in this setting, let me develop the argument that I want to speak to you about in relation to the role of the International Law Commission, and do so in 3 steps. I will first outline the historical journey in this regard, and explain where the work of International Law Commission fits together in elaboration of these rules. Secondly, I will explain how International Law Commission contributed to the topic, particularly through the work of the penultimate special rapporteur, Gaetano Aranjo Ruiz, in early 1990s, and the final fifth special rapporteur, the great and much missed Professor and Judge James Crawford in the second reading. And finally, with a forward-looking eye, I will say something about the future contributions and current contributions that the International Law Commission may have on the topic. So where do we begin? Analytically speaking, the law of compensation is situated within the broader rubric of the law of international responsibility, which has classically, within public international law setting, been addressed as law of state responsibility. State responsibility for internationally wrongful acts. And if we go back to the traditional international law that we would have addressed if we dealt with this issue a century ago, there we find ourselves in the world of such authorities as the judgment of the Permanent Court of International Justice regarding factory at Chorzo, where the court noted, among other things, the importance of the principle of reparation for an internationally wrongful act, of which compensation constituted an important part. At the same time, most of arbitral practice in that setting and state practice were articulated in terms that strike us from the contemporary perspective that emphasizes sovereign equality of states as somewhat or significantly problematic, reflecting, as they did to a considerable extent, the particular perspective of traditional home states, so states based in Northern America and Western Europe, that espoused claims, often in the context of protection of their nationals abroad or their property abroad, in Asia as well as in Latin American countries. So there's a general sense that while many members of the international community endorsed the broad propositions about responsibility and compensation, the particular examples of their implementation were wound up with the injustices and imbalances of the traditional international legal order. Nevertheless, even in that setting, it is worth noting that states that convened in the 1930 Hague Conference for the Codification of International Law that addressed, among other things, state responsibility, were able to agree in the first reading on a statement regarding compensation, albeit then viewed somewhat simplistically from the contemporary perspective as limited to responsibility for breaches of the rights of foreigners. So that is the legacy that the pre-Second World War international legal order provided us with. What about the post-Second World legal order? And as I said, there are some judicial institutions that did not really provide us with much. The International Court of Justice did not give us more than the Corfu Channel case, where, as I said, we learned something about treatment of non-appearing parties before judicial bodies, but very little indeed, that international lawyers and other states interested in practical implications of state responsibility could build upon in terms of methodology and analytical questions to be asked. Not much more was provided in later years either. So in Gabčíkova Najimara's case, for example, in the 1990s, parties did not put forward a claim for compensation, reserving that possibly for a later stage. That did not come. In another case, in the 1974 judgment between Germany and Iceland on fisheries jurisdiction, the court noted that Germany had failed to provide detailed evidence. And in the one case where a very thorough submission on reparation and compensation was provided, the original Nicaragua case, so to speak, the much cited military and paramilitary activities case in the 1980s, ultimately Nicaragua did submit, after the court's judgment on the merits, a very thorough memorial on compensation, but in early 1990s, the case was discontinued, so the issue did not go anywhere. You will also know, thinking more generally perhaps about the institutional developments in international law, that there wasn't a great deal in terms of activity of international courts and tribunals during the post-war years. The usual way of settling disputes from before the Second World War through arbitral commissions and arbitral tribunals essentially collapsed. Apart from several ad hoc mechanisms, there wasn't a great deal that would have contributed, apart from the very particular mechanism created in 1980s, which was the Iran United States Claims Tribunal. And what we see starting in 1990s is really a sort of a sense that most interesting developments are not taking place where one would usually expect it to take place in international law before the International Court of Justice or interstate tribunals, but rather in various specialized mechanisms. So those could be the Iran United States Claims Tribunal I just mentioned, regional human rights courts, and here the inter-American bodies in particular were influential, as well as other bodies like International Tribunal for Law of the Sea, for example. And so that is what we have. That is the practice that frames the world within which the International Law Commission came in during the 1990s. Before I turn to my second point, as it were, what it was that the International Law Commission did, let me just say, leaving the International Law Commission aside, albeit which is a hard task to do because of the very important role that its work played in framing the area, that after that, one might say in the next 25 years, for many of us as international lawyers, in living memory, we can remember these cases being presented and decided, much more happened. So regional human rights courts dealt with in much greater detail, not only in the inter-American context, but also in the European and more recently the African context. International Court of Justice, in addition to the case I mentioned decided last year regarding armed conflict, handed down two very important judgments in the Diallo case between Guinea and DRC regarding compensation for human rights breaches, and between Costa Rica and Nicaragua regarding compensation for environmental breaches. And a great deal has been decided in other settings, in law of the sea arbitrations, in interstate human rights cases in European context, in a really burgeoning diet of cases considered by human rights courts and investment tribunals within the broader institutional framework, like, for example, the Palestinian damages register under the auspices of the United Nations, as well as presented in state claims. As I noted, this is a tendency that seems to be ever increasing. Some of you who are following the work of the International Court on Climate Change will know that late January is a deadline for submitting written statements in the advisory proceedings regarding obligations of states in relation to climate change. And there, question B speaks about legal consequences arising from a certain aspect of state conduct. And It is arguable that some states may raise the question of the broader rubric of responsibility as well in that regard. So a great deal is taking place. How did the International Law Commission fit in there? And here, my submission is that even though international law has been successful in building up what one might think a mythology of long-established rules in the area, in effect, for practical purposes, international law of reparation and in particular compensation was shaped, if not on some points created, crystallized by the work of the International Law Commission throughout the 1990s. And this is something that came in two guises. One guise was the work of the fourth special rapporteur, Gaetano Aranjo Ruiz, in late 1980s when he submitted his first two reports, and then in the first half of 1990s, particularly in 1993 and 1996 when these reports were discussed by the International Law Commission. And there, the question really was, and it was raised in various ways by academic commentators and states, about the extent to which sufficient density of modern relevant practice existed. The great Christine Gray wrote her first article in the British Yearbook in mid-1980s asking whether there was an international law of remedies, and she was quite doubtful about it. In her view, while there were cases, they were very old, fragmented, and not entirely consistent. And that was also the view that was presented by some states. United Kingdom, for example, intervening in 1993 before the Sixth Committee of the General Assembly, said essentially that all of these cases were somewhat dated and really did not speak to modern challenges. Recall that many of them were decided before the Second World War in a world that was very much shaped by the imperial powers and in a manner that did seem to rather unlikely to reflect a balanced view of the rules on the issue. Aranjo Ruiz presented several draft proposals that were broadly accepted by the International Law Commission, leaving itself, however, mostly at the level of rather general principles. Again, very sensibly, International Law Commission found that mostly the practice on this issue was not sufficiently dense to provide more practical guidance other than things that would be familiar to us from basic tort and delict law about responsibility of state and obligation to provide compensation for loss or injury that has been caused by the particular wrongful act. In 1997, the project was taken over by the great James Crawford, who was given the task to prepare the project for the second reading. And there were many things that Crawford, International Law Commission, and states struggled with in that setting. One particular point, and I think just to note, I think the both importance and the slight unease with which international law deals with these issues was the concept of what Crawford called crippling compensation. And that is something on which I have written, and you may be interested in seeing the full version of my argument in an article in Modern Law Review a couple of years ago. So the question was whether the responsibility regarding compensation took account the capacity of states to pay. And that was a very interesting and hard question. On the one hand, from the three forms of reparation that were provided as part of international law of responsibility, both restitution and satisfaction, provided what one might call exceptions of disproportionality. So restitution cannot be disproportionate, satisfaction cannot be humiliating to the responsible state. The rules on compensation did not say anything on the matter. And some members of the International Law Commission raised it as concerning in their first reading, mostly in relation to possible investment claims, in the second reading, in relation to war claims. And in a way, I think that is perhaps the small practical insight to note here, that it seems, looking at the work of the International Law Commission, that it was to a considerable extent influenced by the assumptions of what sort of claims one might usually expect to have in international law. And unsurprisingly, in early 1990s, with the background of the Cold War debates and the new memories of the new international economic order, those were economic and investment claims that seemed more concerning. In the second half of 1990s, investment claims no longer seemed particularly relevant, and rather the thing that was formulating the background assumptions was the United Nations Compensation Commission, and therefore the war claims. And Crawford addressed the issue squarely in his third report and concluded that, in his view, there was no need for having a particular rule on disproportionate, excessive, particularly crippling compensation claims. Crawford pointed to the fact that most claims were relatively trivial in amount compared to the overall capacity of the state. So most cases would not raise that issue. To the extent that we speak about interstate claims, a sensible state would simply not make a claim that is likely to bankrupt its members. So that was the way how the lessons of the Versailles Treaty were perceived in 1990s, that you do not want to bankrupt your neighbor because that is likely to lead to long simmering disputes. Even if claims were brought that were large in amount, they are often inflated and rarely awarded. And Crawford said, to the extent that there were very significant amounts, one could trust the wisdom of the broader international legal community reflected in the institutional setting. And there, I think he was influenced about the practice of the United Nations Compensation Commission, which explicitly took into account the needs of the Iraqi people in awarding compensation, or ultimately perhaps rules on necessity and other circumstances precluding wrongfulness. And I think it is important, and I think it's not to suggest that the great James Crawford or the International Law Commission in 2001, in its work on articles on responsibility, got anything wrong about international law as it was at the time, but simply to emphasize the shift in institutional assumptions. So I think many of the assumptions that International Law Commission took as a given, elements of normality of international law, no longer really accurately reflect contemporary international law 25 years later. I don't think that we can easily trust the wisdom of the broader system as reflected in the Security Council and its capacity to make appropriate adjustments in these settings. I think, while this is not a talk about the international institutions, I think that probably the contemporary sense about the potential and the effectiveness of Security Council, in particularly politically contested matters, is somewhat lesser than that of international lawyers in 1990s. Look at the frequency in which Uniting for Peace resolution, for example, has been invoked in the last years. We also see that these very large claims are actually brought. I mentioned the last year's judgment in the DRC and Uganda case. In that case, DRC brought a 12 billion claim in relation to very significant breaches as part of the military conflict that the International Court had identified in an earlier case. And also, most of the modern cases are really driven by non-state actors in the human rights and investment setting that might not have that long-term institutional balance. They don't feel that they are repeat players in the way how states are. So it's not a critical judgment about non-state actors, but simply institutionally speaking, a state that is thinking about bringing claims necessarily has in its mind the reciprocal mechanism. If I am making claims, it legitimizes and provides legal endorsements for similar claims to be brought against me. If I am bringing the claims, that might establish a certain legal proposition that might be invoked against me. A non-state actor, whether a human rights or operating in an economic context, does not have that long-term repeat player perspective. They are mainly interested in vindicating their injured right. So I think that was the question that I asked in an article, whether contemporary international law has changed in its basic assumptions in the last 25 years to a significant enough extent for us to revisit critically what the International Law Commission had said on the particular issue. In the Congo and Uganda case, Uganda, in fact, raised that argument, and the International Court of Justice ultimately left the issue open because it concluded that in the circumstances, the amount that was awarded, which was, I believe, less than $500 million, while very significant, did not rise to the level where we had to consider such matters. But plainly, I think what it does illustrate is the importance of careful reading and evaluation about the extent to which the work of the International Law Commission fits within the contemporary legal framework. So I think the takeaway I would have from my second point, which I'm now concluding, is that the International Law Commission did an enormously important work, one that has been subsequently largely endorsed by courts and tribunals to the extent that they have addressed the issue, the basic propositions on compensation being a customary obligation, rules on causality, rules on contribution, to some extent also rules to mitigation, but their practical applicability in various settings still lags behind this general legal principle. And also in many important respects, one has to read carefully and faithfully and very seriously, but not perhaps dogmatically, the work of the Commission. Now, what about Commission's contribution in the future? And here, I know that the International Law Commission did return the question on compensation several times after 2001. In 2011, it again addressed the issue in its work on responsibility of international organizations, expressing the rules on content of responsibility in effectively identical terms. And this is something that was also addressed more recently in the principles on environmental protection and armed conflict adopted in 2022, as well as in Special Rapporteur Sturmer's work on succession of states to state responsibility. And in 2017, the Secretariat of the International Law Commission prepared an outline of possible long-term projects that the International Law Commission may want to consider in the future. And one of them was compensation under international law. So I think probably the overall message that I would want to leave here is perhaps a somewhat nuanced one, and one that doesn't comprise itself elegantly into a simple punchline. This is a very important topic. It is very important before international courts in a wide variety of areas, all of which touch in one way or another on key aspects of public international law. So reparation for armed conflict, reparation for environmental damage, reparation for breaches of human rights law. The work in the Caribbean context, Brattle Group has prepared evaluation report regarding transatlantic slave trade. So again, also the point about these very practical questions going really to the next stage after the question of responsibility regarding calculation and further practical implications. So these things are important. And I think those of you who have worked in practice in international law will appreciate the way how international courts and international institutions operate in some way as proxies for processes that will be operating unseen in the chancelleries and ministries. For every case that is being brought before a tribunal, there will be dozens of cases that are seriously being prepared for being brought or for being defended, and hundreds and thousands of cases that could potentially be brought if circumstances suggest that they might. So the fact that there are more cases on this issue than perhaps in the international court for the last 100 years, so to speak, suggests that even more might be heading this way. And as I noted, this is an issue that may be relevant in some of the important pending cases as well. This is an issue that, even though in some sense certain propositions are of long-standing pedigree, going back to the Permanent Court of International Justice, the essential elements, in my view, really came together relatively recently. One might say, even within the living memory, this is a product of 1990s, of extraordinary intellectual concentration by some of the greatest minds of international law, but also one that do reflect the institutional assumptions of the 1990s, that to a significant extent are accurate in contemporary law, but not invariably, and therefore have to be applied with nuance and care. And I think that is probably my more future-looking hypothesis or submission, that this is a point to be looked at seriously. I think that this is perhaps the one point where law of state responsibility is comparatively not as granular, not as detailed as international community might wish. These are not the points that international lawyers really focused on when they thought about state responsibility in 1990s. They rather thought about countermeasures or erga omnes claims or criminal responsibility of states or third-party countermeasures. I think that contemporary international law needs to address these things at the generalist level. There are specialist institutions where these issues are looked at. Anti-Trial Working Group 3 in relation to investment arbitration reform does it. But it is perhaps my sense that international law would benefit from general rules on the area, and it could well be that the International Law Commission is a well-placed institution in that regard. And that would probably be the place where I draw the line on my presentation and look forward to the questions to continue this lively debate. Thank you.
Thank you for your excellent talk. And for those of you who are interested, I have provided a link to the Modern Law Review article that Martins was referring to in his lecture. And he also has written a blog essay on the EASL talk. So the link to that article is also there. Martins, the first question that I would like to ask you is on the moral hazard. So yes, I fully agree with you that maybe in some cases, particularly as you have very rightly pointed out, that the identity of the claimants have changed. So maybe when the ILC was deliberating on these, most of the claims were interstate claims. But these days, many claims are by investors or individuals. But in any way, if the ability of the respondent state becomes a factor, could it create some moral hazard that there may be more reckless behavior by some states. Some may argue that. How would you respond to that type of a concern? Thank you.
That is a great question, and I think that this is something that and I think I know that we spoke about, and I know that you have very carefully engaged with my article. My submission is not that an exception to compensation by reference to ability of the responsible actor must be a rule. And I completely agree that there are significant costs in introducing that, and I try to be quite explicit about them, both in terms of destabilizing what is otherwise a fairly clear proposition. And I think as a general matter in law, sometimes it is better to have a clear, if unsatisfactory, rule, because it provides the background against which relevant actors can settle and negotiate, rather than providing something that is possibly favorable but unclear. So that might endanger more disputes, more controversies, and that is probably not the direction that one necessarily wants to go to. So probably my argument is a more modest one, that I think that we have to be also clear about the costs that having a very clear rule that excludes in absolute terms the relevance of the capacity of the actor is problematic. You're right that it would seem troubling to suggest that an actor is responsible if they do a small wrong. But if they do a very significant wrong, to the extent that they are unable to deal with the consequences, that is something that in a way, one might say, if you sort of go to a certain extent, and if you are going beyond what you could pay, then all the other wrongful things you can do are, as it were, as an optional extra. You're not going to be in a worse position because you have already reached your bankruptcy level. And I'm simplifying here. I think that is one way of looking at this issue. I mean, the further, I suppose, the added argument could be that, and I think it was something that was argued in the Congo and Uganda case by my great colleague with whom I co-teach courts and tribunals, Philippe Sands, who argued on behalf of DRC that, well, the ability to call for full compensation is a very important part of the broader credibility of the United Nations, because the case in question related to use of force. And therefore, the ultimate, as it were, the purpose of United Nations is to prevent the scourge of war of scarring the future generations. And to the extent that those might be particularly the sort of acts that lead to damages that might be hard to compensate, again, sort of the background of Versailles Treaty comes in. Precisely, perhaps the idea that a state might have to pay a disproportionate price might be a thing that might incentivize it not to undertake that behavior. There are other arguments as well, and Judge Ad hoc in that case, the judge who had been appointed by Congo, noted in his opinion so one other morally problematic aspect, that to the extent that it were to be taken into account, in a sense, a loss has to fall somewhere. And if a respondent state has caused damage, which is it is unable to compensate, it means that the damage will then be carried out by the victim. If we simplify it in very domestic private law terms, if somebody breaches a contract and the loss caused is £15, and if they cannot pay more than £5, it would mean that the loss of £10 would then be would then be carried by the victim. And here the argument is, if one considers it, whether it is the state that has been found responsible or state that has been the victim of breaches of international law, ultimately is even less so deserving and an appropriate final addressee of these matters. These are extremely hard questions, and I'm certainly not suggesting that all normative intuitions point in the same direction. I guess probably my ultimate pushback is against the ILC's assumption that these are things that would not really arise, that the bigger system will take care of these. And that, I think, has been somewhat discredited by the practice. They have to be faced. They cannot be bracketed out by saying the politics or the individual wisdom or the system will take care of that. That is something that is coming up before states and before courts and tribunals ever again. And I think our responsibility as international lawyers is to engage directly and squarely, just as James Crawford and the ILC did. They did it with incredible honesty and analytical clarity. And the fact that we might reach slightly different conclusions in contemporary law does not diminish to the slightest extent the incredible respect that I feel for those international lawyers.
Okay, Martins, there's hardly perhaps any international law academic who disagree with you on that point. And maybe they needed a crystal ball to foresee the way international dispute settlement would evolve in the next few decades. Now, my next question would be that I'd like to put to you is from Amin Hamza, one of our graduate students. And I would also link a question to that question. Hamza asked you that has the opportunity to challenge the permissibility of crippling compensation been lost due to states' failure to object? And when I read your article, it was also, I think, pointed out by you that only few submissions which were made on that issue of compensation or crippling compensation was mainly from some OECD countries. Perhaps there was hardly anything from the global south. So if that is the case, do you have any views that why it was so? Why was there so few submission from the other states? Thank you.
That is an extremely interesting question, and I have discussed it with a variety of actors. We're both currently with states and international institutions and those who have recollections of those times. And I think probably also perhaps a slight, one pushback, one perhaps slightly critical point that was raised was whether I had not been perhaps somewhat hasty, if not stating, then perhaps implying that it would have been more likely that the global south, third world states would have been critical of the matter. In a way, that is a challenge of deciphering the silence of states, where one might make plausible inferences on what they might have said, what they had said during the new international economic order debates, what they might have said in later contexts, but ultimately state practice, opinio juris in these matters is articulated when it is articulated. And I think one explanation, at least for me, is that 1990s were a peculiar time in many ways. So a very inspiring time in many ways. That was, I think, really, we see that many people began their public international law journeys in 1990s or inspired by the institutional optimism of 1990s. We see institutions being created, international judicial bodies being created or becoming more active, and there being a bit of a promise of international law. It is possible that that was something that was not simply considered an issue, because historically speaking, many of the claims that would have been considered and that made states cautious. I think that is something that made states cautious in the members of the International Law Commission cautious in the first reading. Judge Bennouna, for example, who had been the ILC member from Morocco, had written a great deal on the new international economic order, raised precisely those points. The Chinese member who went on to become the president of the International Court, Judge Xi, also raised those issues. So there was so what sort of cases are we thinking about? Possibly, I think that there was a gap, an intellectual gap that is now very hard to imagine, because disputes about investment law has been probably the last 1.5 decades one of the most controversial fields of international law. And global South scholars and also states have been vocal in their criticism. And I think that in the 1990s, it really seemed that perhaps this was no longer the field that was particularly contentious. The new international economic order debate appeared to have been concluded, while investment treaty debate had not yet taken off. So that is that temporal gap into which ILC assumptions fall. And then if we look at the regional regimes, so some of it is in the European context, some cases in the inter-American context, but then I think that Crawford's point that really in the human rights context, which is really not mainly about compensation. Human rights, legally speaking, are probably mostly about cessation of wrongful conduct, changes in laws, restitution, juridical restitution, as it were, letting arbitrarily deprived people out of prisons and so on, that the focus is not really there. So the states that are intervening are those, in a way, the United States, that is a litigator before Iran United States Claims Tribunal. United States knows that these are important issues. There will be countries who are maybe having foreign investors that are coming to them and saying we are in danger of being expropriated. But I think really the interesting and striking thing in light of the importance of the topic now is that even many states that are deeply engaged, what one might think more from the claimants' side, we're not really too deeply engaged in the issue at all. And, it's quite possible that, certain things that we take as a given of functioning international courts, the sheer routineness of having important international issues referred to formalized dispute settlement, increasingly with far-reaching claims for reparation, was something that was not simply considered as a routine challenge that international law and lawyers would be facing. I think it is important not to be smug, not to be anachronistic, because the work on state responsibility was an extraordinary achievement, arguably the greatest achievement of the last 30, 40 years in that field. It was wonderfully sophisticated, wonderfully deeply engaged with, but it does seem that neither scholars nor states appreciated this particular factor, and admittedly it did take about 10, 15 years after that to play out. Just probably the last point to note is that B.S. Chimney had written a very interesting article in the European Journal of International Law a couple of years ago about third world approaches to international law and state responsibility. And he was quite critical about the ILC's approach on compensation on these matters, possibly a bit too critical, but I think that there is an important insight that these were hugely important issues that third world, global south had effectively, even if not under the same nomenclature, been dealing with in the General Assembly for many years. And then there seemed to be that attention dip just at the most important moment when the issues were addressed. there's absolutely more work to be done in this area, I think. And that is perhaps really one of those things that are most interesting in international law, explaining why some things that one might plausibly have expected to happen did not happen.
Now, our next question is from Saleh Shafi. So he puts in a hypothetical scenario and says that if state A violates international law and commits crimes against humanity against a particular race X of state A, and this state A is being funded and weaponized by state B, can state B be also held liable and made to pay reparations to the vulnerable people of state X? Do you have any views on that?
Right. I think that these are extremely interesting questions. I think as a general matter, to the extent that rules of international law are structured for the benefit of individuals or groups, breach of those rules will certainly require for reparation for the benefit of those groups. And I don't know whether Saleh is thinking with the particular case in mind, but I would imagine that in light of the geographical contiguity, the Gambia and Myanmar case must be quite close to the minds of your academic community. And that is the way how the Gambia has formulated its claim, asking for a reparation for the benefit of the Rohingya community. So that, I think, is one element of the question, and the answer there has to be, I think, tackled by reference to the type of the obligation that has been breached. Is it an obligation for the benefit of a state, or is it an obligation for the benefit of other addressees? The second half of the question, I think, is something that goes either to particular rules regarding responsibility for engagement in indirect form or through support of international crimes, or through the general secondary rules on aid or assistance. And that is something that the International Law Commission dealt with in Article 16 of the 2001 ILC articles, where it accepted that in certain circumstances, aid or assistance can be a ground for responsibility. And there has been a lot of very interesting scholarship on the matter. The three foundational books by Helmut Horst, Vladislav Lanovoy, and Miles Jackson in particular, as well as the work by Andre Nolkembert and associated colleagues in European Journal of International Law on shared responsibility principles. And I think those Article 16 at least was recognized by the International Court, if somewhat incidentally and without a great deal of reasoning, in the Bosnian genocide case in 2007 as being reflective of customary international law. So I think that to the extent that the relevant legal criteria are satisfied, one might reach the conclusion that reparation has to be provided also by the state that is aiding or assisting. I think that once we reach that stage, the hard question arises regarding the plurality of responsible states, for which the rules provided by international law are, in my view, not entirely clear. And that is, again, something that there could be more granularity provided, perhaps by the International Law Commission, of what happens when multiple actors have co-contributed, if in a variety of ways, to a single wrongful act or to a series of wrongful acts, or perhaps a complex wrongful act, to use the ILC terminology, whether there is an element of, whether full compensation can be claimed from any of them, and then they can just have to share their compensation internally, as it might be under certain domestic legal orders on joint and several liability, or is there a sort of division of responsibility by reference to their internal contribution? The ILC says that in relation to contribution by number of factors, to the extent that they have all caused wrongful act, that does not diminish the percentage. So in a sense, everybody who has contributed, if they are truly responsible, have to pay for the full loss, even if somebody else has contributed as well. It's up to them to sort it internally. But it is not entirely clear, perhaps, whether that proposition also applies to the mutual relationship between the responsible actor and a third actor that has aided and assisted the responsible actor. So I think that Saleh's question is a very good one and a very hard one as well. But international law of responsibility at least identifies the relevant questions that we ask to reach the right conclusions.
Thank you for that answer. I was thinking that maybe it could also be, although in no way there was any reference to it, about the situation in Gaza, and maybe it could also allude to the US support for Israel. Of course, I do not know it, it's just our guess. Now, we're almost out of time. My last question to you would be on the jurisdictional immunities case, Germany versus Italy. I cannot recall the precise paragraph number, but I think there was one observation, if my memory serves me properly, that the court has addressed this point that there may be situations where a state, of course, in that case, as we all know, the emphasis was on immunities of a state in the domestic legal system of another state. But I think one point that ICJ was making was that there can be situations that a respondent state may not be able to make full compensation. So if I have read it correctly, could we argue that in a way the court was actually giving an indirect authority for limiting some sort of crippling compensation in future cases? Could we read that into that judgment? Thank you, Martins.
Thank you. It is a very good question. I would have to carefully reread the judgment with your question in mind. I think it is an important insight that you raise. At least off the cuff, my reading of jurisdictional immunities was mostly standing for a different proposition. And I think, as you very rightly say, the legal issue in the case was a different one. The legal issue in the case was about immunity before domestic courts. But in the general, as it were, background discussion, one issue that did come up was regarding the effect of interstate settlement agreements on claims brought by non-state actors. And I think that one of Germany's points that Germany made was that actually these are things that it had settled with Italy in the post-World War settlements, including, among other things, a certain amount of funds that had to be passed on to the victims of the sort that were raising the claims. And that, I think, is an interesting question. I think as a general matter, to the extent that we are speaking about a simpler situation of interstate claims, I don't think that anybody would challenge the proposition that states can completely waive the claims. And they can qualify the claims. So, you know, if I owe you £10, you may waive that claim completely, or we may settle that I pay you £5 and you say that our dispute is settled and no other claims to Martins will be raised. That, I think, is right as a general proposition. These are things that are dispositive and can be waived. The harder question, but I think ultimately it did remain in the background, even though some of the judges in their separate opinions addressed it, is whether it is qualified by the fact that particular obligations are owed to non-state actors as well. And I think that there's also a standalone question of whether the rather ancient rules of or law of war in that point are of that sort, or whether they are the things that are not owed to individuals, but are there for the benefit of individuals. But to the extent that we are in the human rights world, for example, where the rights would be explicitly owed to individuals, there I think the logic would be to say that I might be owing an obligation to two separate addressees, to the state of nationality and to an individual, or perhaps if it's an erga omnes obligation to all the other parties, to the instrument erga omnes partes. And the fact that I settle it with one doesn't mean that I settle it with the other one, or if the fact that if I waive the claim, it doesn't mean that individuals necessarily waive the claims. And those are, I think, that the sort of questions that I'm sure that you and the audience would be much more familiar with, but that have been dealt regarding the implication of the San Francisco Treaty and other related agreements in the regional setting regarding responsibility of Japan and the ability of non-state victims to invoke it. So I think in a way these things connect together, but they connect together perhaps as an example that even if we are speaking about unimaginably awful things, like those that were the underlying cause of domestic claims in jurisdictional immunities, they may be still subject to waivers and settlements. I think that was something that Germany incidentally raised its question, that there was a great deal of suffering in the Second World War by many, many actors, and a great deal of that was actually resolved by settlements. And it was not always necessarily the worst thing that not everything happens through money. Broader establishment of good neighborly relations, perhaps certain institutional support, communal relations is also, perhaps in the more creative way of thinking about reparations, as the Inter-American Court of Human Rights has done, is also extremely important. But I think that you are right, that there's a great deal of subtle indicia about a variety of ways how international law is dealing with things that we can derive from international practice. And I think the crippling compensation question is an important one, but it's also important to be read in context, that is absolutely not the only game in town. It is part of a web of sophisticated and nuanced international legal argument that we have to take seriously and to engage seriously and with a humanitarian perspective and frame of mind if we want to reach just and sustainable a future of international legal order.
Thank you, Martins, for that answer, for your excellent talk. Thank you to the audience for your participation. With that,
it was a pleasure. It was a pleasure to be in the virtual space of NSU, and have a very nice evening, everybody.
You too.